The second session will be Case Law Update, Part 2, the continuation of a review of case decision originating with the WCAB. Again, our panelists include Mr. Jason Marcus, Mr. Dudley Phoenix, Mr. Richard Jacobs-Myers, and the moderator, Mr. Richard Montalvo. Let's join our final session, which is underway.
We're going to begin where we left off on page 11, and we're going to just kind of shotgun these. The box is captioned Medical Legal Procedures, and I think we're going to take two apiece. So we start with Jake.
Yep. Okay, first one, Hill versus County of Alameda. This is one where I believe the applicant tried to challenge a QME report after receiving it, making an argument on a number of technical challenges. Now, we all know that you can't challenge a QME report for being late once you've received it. So that probably was not one of the technical challenges that was raised, but there are other technical challenges. I've actually part of a process that reviews QME reports for quality assurance for the DWC, and they give us a list of things that are supposed to be included. You're supposed to include the applicant's birth date on the report. It's supposed to be in there. If you don't have the birth date, it's a technical defect. We all know there are certain declarations under penalty of perjury you have to have. There are declarations about if anybody else participated in the report that you have to have. All of those are technical issues. And what the board ruled in this case was those technical issues essentially can be cured, and the applicant's objection to the report based on those technical difficulties is not a basis for to strike the report. But the real reason the applicant attorney was looking to get rid of the report was they didn't like the report, and they're not going to let your doctor shop based solely on technicalities. If you want to challenge the report, you can get a rebuttal report from the treating doctor, or you can have the applicant be reevaluated, or you can depose the QME. But you can't use a minor technical defect as a basis for challenging the report. Only those things which allow the report to actually be challenged, such as ex parte communication, objecting to the report before it's late, before it's received because it's late, those kind of challenges.
I hope not. I don't know.
The second case, which is, and I see the spelling is Garcia, but it's actually Garcia. The L is a misprint. So if you look for the case, you would look at under Garcia versus Food for Less. In that case, the applicant attorney wrote a letter to the QME, but served it on the applicant, on the defense attorney first, asking the doctor to comment on the application of kite and sending a bunch of other materials, including some case law and other materials. The defense attorney objected, but before the objection, the applicant attorney actually sent the letter to the doctor with the materials. When they got the objection from the defense attorney, they called the doctor's office and said, don't write that report. There's been objection by the defense attorney to the report. We need you to not write it till we get it straightened out. The doctor told the assistant calling from the applicant attorney's office, it's too late. I've already dictated the result and it's on its way out. Apparently there was also some discussion about the merits of kite between the applicant attorney's office and the doctor. And when the issue came up before the board said, well, the letter was not ex parte communication because it was disclosed to the other side, but the communication with the doctor by the applicant attorney's office was ex parte communication. And so the report was stricken and was not allowed to go forward on that basis.
I think the next one's mine, Rich?
It is. The next two.
The next two. Okay, so the next case, it's Jones versus Corkscrew Cafe. Basically, this is consistent with what we talked about earlier, that when you're looking at Navarro issues, the claim form or the filing of the claim form is the operative act. So if the claim form, regardless of the period of injury, or the period of the cumulative injury or the specific date of injury, regardless of the dates of injury, if the claim form itself is filed after the examination, you qualify for an additional panel. So that is the Jones case. The second case, Gill versus County of Fresno. This too is consistent with one of the earlier cases that we talked about. Here, a letter went out by the applicant's attorney requesting a medical evaluation immediately after filing the claim form. The board there said, hey, that was enough to generate a dispute warranting the request for a QME panel. Again, I don't know, these cases are really helpful for getting a panel earlier in a claim, but I don't know what the medical unit's going to do with these new cases. And again, I think the direction is going to have to come from the DWC that they're going to start issuing panels, and I don't think that has yet happened.
All right, moving on. The next case is the Baker case. This one's a little personal because my partner, Brian Pulley, and my office actually handled this case.
Oh.
He won at the trial level and then lost on recon. So here's what happened. We have an accepted case, and the surgeon submits a request for authorization for fusion surgery that is approved by UR. However, due to an inadvertent mistake, the RFA listed the wrong level. It was one level off in the spine. The day before the surgery, the surgeon realizes this, reaches out to the carrier and says, hey, let's fix this. Will you authorize it and correct it so that it's at the right level so that I, the surgeon, can get paid? And the carrier says, well, we really need a new RFA. So they submit a new RFA. Ultimately, the surgery goes forward, and then the RFA comes back denying the surgery. Now, I have no explanation for why, on the same set of facts, the UR would authorize fusion surgery at the apparent wrong level, and then when the request is sent in, again, with everything the same except for instead of L4 or L5, it's L5S1 or whatever the change was, it gets denied. So we go to IMR. IMR, as you might imagine, upholds the UR decision, go to hearing. The judge determines that the judge, had jurisdiction to address the question of medical necessity, said that, I'm going to read this quote. This is from now retired Judge Cleveland. This is great. He said, this particular appeal from IMR, or rather the IMR decision, is reprehensible in that everyone involved, other than the applicant, engaged in such poor medical and claims management that she, the applicant, now finds herself stuck in a morass that is typical of the present-day workers' compensation system of resolving medical disputes. I could not agree more. However, on recon, defendant reconned after the judge issued a finding saying that yes, he had jurisdiction, and yes, the UR was wrong and the surgery should have been authorized at the correct level. The board reversed and basically said, absent a finding that the UR is untimely, the board completely lacks jurisdiction to address medical necessity, and despite the fact that there's a common sense understanding that it was approved at the wrong level, ultimately that's a medical decision left to UR and IMR, and so the worker had no remedy other than going through the UR and IMR process. Now that was remanded, and I can't tell you how it resolved. I'm sure my partner somehow settled it or worked it out, but just a very frustrating decision. Next one is the Medeiros case. This is a Romero-type situation, although a little different facts. In this case, the worker obtained a QME panel and was evaluated by that doctor while unrepresented, subsequently became represented, and then I believe it was the defendant who sought to replace the QME under Romero. And what the board said is, no, you don't get a replacement on those facts. One, because Romero is permissive. In other words, Romero doesn't dictate that a worker who gets a QME while unrepresented and becomes represented has to get a new QME. Simply the worker may get a new QME. But two, the difference in this case is that while in Romero, the worker had gotten a panel but had not been evaluated before they hired a lawyer. Here, the worker had both received a QME panel and been evaluated by the panel QME and then became represented. So I think the takeaway is, and I think this is, at least in my practice, well settled, if a worker while unrepresented gets a panel and is seen by a doctor, then hires a lawyer, you don't restart the process, you stick with that QME.
Let me just comment on Jason's attitude up here. Every time he hits this table, and he's doing it purposefully, my mouse jumps around and I'm having to move. I think he's doing that to break my chain of thought. It's not going to work. Okay, I have the last two. And the Bonview versus Fox Studio case. At the bottom, unilateral withdrawal from an AME is not going to be allowed unless you're in the Yobart versus Southern Glacier wine, where it may be allowed. So there's a split there. What I would say about that, if you're going to enter into an AME, what the hell? It must be a situation where where the attorney thinks he has authorization, he enters into it, and the adjuster says, no, we don't do AMEs, something like that.
Or I've got a slightly different situation. Injured worker has an attorney. That attorney agrees to an AME.
He's being quieter now with his hands.
That attorney agrees to an AME. Worker then switches applicant attorneys after the agreement to an AME, but before the evaluation takes place. New applicant attorney says, never in a million years would I agree to that AME. Are they stuck with that agreement, or can they abrogate? Now, I'm not suggesting they should abrogate. I'm asking as a hypothetical, could they abrogate?
I don't know.
I litigated that.
I think the answer is no.
Yeah, I
I
litigated
think
that issue all the
Yarborough
way.
was wrongly decided. There's like 4 or 5 board panel decisions after Yarborough that have disagreed with it.
Yeah.
So I think Yarborough is probably questionable law at this point.
Yeah.
And that once you make an A agreement, you're stuck
But
with it.
these are, Jake, these are all panel decisions, right?
But
They're all panel decisions.
Yeah.
Well, I litigated. I subbed in on a case where there was, unbeknownst to me at the time, an agreement to an AME that I would not use. We went to trial on that. The judge did not let me out of the AME agreement. I reconned it. The commissioners did not let me out of the AME agreement, saying that an agreement between counsel is binding even where there's a change of counsel. So, that can be really frustrating to deal with.
But it can cut both ways too, right? I mean, if I make a deal with Rich here and then Rich gets subbed out, which obviously never happens, but again, hypothetically, it might happen.
It should never happen.
And the new defense attorney says...
The one time it did, the client, rued the day, but...
But, I mean, look, I don't want to be in that position of having to abrogate, because I think we stand by our word even if someone else made it. But yeah, I think it goes both ways, right? If a new defense attorney steps in and says, we're not going to use that doctor, I would probably raise holy hell, so...
Yeah. Okay, the last case that
And by the way, it applies also if the applicant discharges their attorney and now they're stuck with the AME agreement their attorney made. So now you have an unrepresented applicant who has to live with the AME agreement their attorney made.
And we have some cases saying that they're still stuck with that.
Yeah.
Okay, the last one is, what do you need for a replacement panel? And the case of Ray stands for the proposition you have to show, there has to be a showing of prejudice. You don't automatically just say, I want a replacement panel. Okay, I put one penalty case in just for good measure, and that's Dudley's case, the Carter versus County of Alameda. There's a typo. It's not the country, it's the county.
Yeah, the country of Alameda. Yeah, so this is an interesting case. And, I think the focal point, again, I'm using that word a lot today, but when it comes to penalties, I think most people think of 5814. And I think, historically, we've litigated 5814 issues, and it's always about unreasonable conduct. Can you prove unreasonable conduct? Can you get multiple successive penalties? And those types of issues. The sort of unloved penalty provision is 4650D. That's a penalty provision that's not often brought up, it's not often discussed. But given the limitation in the value of the 5814 penalties, i.e. $10,000, if you have a large retroactive or accrued period of benefits owing, the 4650D penalty can actually be significantly greater than the 5814 penalty. This Carter case sort of exemplifies facts where that can happen. Here, the case went all the way up through the Court of Appeal. Defendant was considering filing a writ with the Supreme Court. Decided not to, and within their appeal period, decided to pay the benefits owing. And when paying those benefits, did not pay the 4650D penalty, the self-imposed 10% strict liability penalty. And their argument was, hey, we were still within our period to file an appeal. We paid it when we decided not to appeal it. And the commissioners here kind of said, yeah, but you didn't, right? You didn't appeal. So if you pay benefits outside of the 14-day period, you have to self-impose on the retroactive amounts paid. So the applicant's attorney, filed the petition for penalties, and sure enough, a 4650D penalty in the amount of $51,000 and change was imposed, as well as a $10,000 5814 penalty. So again, that 4650D penalty is going to be strictly enforced. There's no issue of unreasonable conduct. It's either paid within the time frame or it's not. So that's something to keep an eye on.
Let me just ask.
I actually have some input on this one because I've had this issue come up a couple times.
I have two.
There are three cases that are relevant on this issue. One is a case called Arabia. It's a court of appeal decision. Arabia says you do not have an automatic time frame for delay in paying of an award because there may be an appeal. There's nothing automatic about the 45 days. You get a decision on recon, you don't file the appeal, you don't get 45 days to go ahead and make the payment. It's not automatic. However, in Arabia, they also said if the defendant actually presented some evidence that showed that they were considering the appeal, there may be a basis for delay in that standpoint. A subsequent case, which was a board en-banc decision called Lenion, Leinon, it's a 2004 case, says that the time for consideration of paying a benefit under 5814.5 is when either there's a final board decision or a determination by a party that they're going to accept liability and provide benefits. And in Lenion, the defendant paid after the 14-day time frame, but said, we were looking at continuing to contest this, but after a period of time, we decided not to. We paid within 14 days of that time frame. The court said the time runs from when you make the decision to accept the liability and are deciding that you're going to pay benefits. And then there's also a case called Mike versus WCAB, where they say as long as the defendant makes the payments within 14 days of accepting undisputed liability, 5814 doesn't come into play. In this case, the defendant stipulated that the benefits were due on X date, and they hadn't paid by X date. Therefore, the 5814.5 was automatic. If they had said, we were considering filing a petition for writ of review, and we made a decision on Y date, and we paid within 14 days of Y date, I think they had a good argument for the 5814.5 that it wasn't due. So that's an issue that you need to be aware of in these kind of limited circumstances involving appeals. You don't get an automatic stay of paying benefits just because you might file an appeal. I actually had a case where we considered filing an appeal. We were going to file an appeal. I did a whole bunch of research on the appeal, and in looking at the research, I realized that we had absolutely no chance of prevailing on the appeal for some technical reasons. And I told the client, as of today's date, you're deciding we are not going to file appeal. You need to get those checks out within 14 days of today's date. They did it. Applicant attorney filed a petition for penalty, and I made this argument to the judge, and judge told the applicant attorney, I think he's right. I think they had that time frame since they presented evidence, which was my declaration, that they were considering appeal and actually were intending to file an appeal and then aborted that process during the 45-day time frame.
Yeah.
Just a little wrinkle in the penalty issue.
Yeah, let me say this. I handle it differently. What I do is the first thing I do when I get an F&A back is I immediately, within 24 to 48 hours, send out an analysis letter. And part of the issue being raised is whether or not we're going to pay or appeal. I also tell them that if we're not going to appeal, we have this 14-day period, because I've always been concerned about this, the analysis in this case. But whether we appeal or not, I always contact opposition counsel and say, listen, I think my client is inclined to pick this up, but I need a waiver of penalties. And I always get that from opposition, because you guys don't want to go up on appeal further and further and delay everything. But let me ask everybody this. What if we do file an appeal? Then I think that extends the period of time. Yeah, because we don't have a final F&A.
But it's not final until the last time for, it's not final until the last decision accepting liability or imposing liability. which can be extended by filing an appeal from that. But if you don't file an appeal, it becomes
That's what I'm
final on the
saying.
date.
So I agree with Jake's analysis. That's 14 days from the date that you have undisputed liability. So
And the
if
issue
you
is, what
file
is
an
it?
appeal, yeah, it's not final, and you can't have undisputed liability until you have a final determination. So here, had they filed with the Supreme Court, that would have extended their time frame at which to
That's what-
pay.
exactly.
Yeah, but I also think it's good practice. If you were to call me, Rich, and go, hey, we want to pay this and
Yeah.
take care of this, I think most applicant attorneys would work with that.
I have a question for the panelists. So, here, obviously, applicants sought both 4650 and 5814 penalties, right? But 4650 is the self-assessed penalty. So the question is, does an applicant or applicant's attorney have to claim 4650 penalties for the penalties to attach and be owing, assuming that the carrier has not paid within the timeline set forth in 4650?
Say that again.
In other
No.
words, do we have, I understand to get a 5814 penalty, we have to claim it, file a petition, raise the issue, whatever. Do we have to
Self-assess.
do we have to do that with 4650, or is it something that is, whether we claim it or not, if you don't pay within 14 days of a final order, it's owing?
I think it's owing.
It's owing. It's
That's owing.
liability.
And in fact, in this case, the 5814 penalty, which by the way carried also with a 5814.5, was imposed because they didn't pay the 4650 penalty, 4650D.
right.
The 25% was on the $50,000, not on the underlying benefit. They said that 10% or that penalty is absorbed by the 5814.5, but the $10,000 was a penalty on the delay in paying the 5814.5 in this case. So they got both penalties for it.
Right. So it's any payments outside of the 14-day cycle. I just had a defendant change adjusting companies, and so they didn't pay TD for 3 months, and they paid the retroactive amount and didn't self-impose. That's easy. They owe the 10%, and there's also a 5814. But on the 4650, that I don't have to petition. I don't have to ask. That just is automatic as far as I understand.
I get calls all the time on do we owe a penalty, and I say two things. Number one, it's de minimis. It's not a lot of money. It's because it's on the part that's delayed,
Correct.
whether it's 4650D or if it's 5814. So why are you spending my time on this? I'm going to charge you that amount.
Until you get a case like this where you're
Yeah,
looking at
well,
a
this is obvious.
$50,000.
And these are the ones that go up and make
Yeah.
law for us
Yeah,
and tell us. Okay, the next case is Jason's, but before we go through that, I want to go provide or discuss a little bit about establishing permanent disability under the Fitzpatrick case. We now know that to establish whole person impairment and or resulting disability, we have to have a theory under 4660.1, a theory of disability. And I would suggest, I'm not going to go through 4662, but I'm going to go through the three theories that I think we all need to be aware of. First, there's the standard rating and the standard method chapter or table under the 5th edition of the AMA guides. Here, objectivity is critical because it's the objective findings that lead the doctor to make the proper diagnosis. It's that diagnosis that leads the doctor to the correct chapter, method, or table. Subjectives are important in two regards. First of all, the doctor may add 3% add-on. And the subjectives are important to validate the diagnosis. Okay, set that aside. The second is the Alvarez-Guzman analysis. And we've already had a case where we discussed the elements. And they're as follows. Number one, you have to have the standard method chapter or table. Number two, the doctor has to address whether or not it's accurate, complete, or inaccurate, and therefore not complete. And if the doctor finds that it's not accurate, then he's free to go to an alternate method chapter or table. But here again, the doctor has to explain why that alternate method chapter or table is accurate. Last, we have the Ogilvie-LaBeouf. Ogilvie's dead because of the date of injury. It's applicable. But you still have this argument under LaBeouf based on VR evidence. And here the critical factor is really the Dahl decision. And I think, and I'll throw this out to the panels, this is the way that I explain the Dahl decision. It's a lot like the need for medical treatment prior to PNS. What we want to know is, with medical treatment prior to PNS, we want to know if the applicant has plateaued with respect to their disability. Well, with VR and the Dahl, we want to know if they're amenable to VR rehabilitation. And to have an accurate inability to compete in the open labor market or diminished future earning capacity, we want to know whether or not they can benefit from VR, from vocational rehabilitation. In other words, are they maximally improved? Are we at that point where we can assess the level of disability based on the inability to compete in the open labor market or the diminished future earning capacity? And that's how I see that decision. I put that in my book before Dahl came down in 2014 or something. And the following year, my editor edited that out, who is honestly a much more intelligent person than I could, and more. That's Robin Kobayashi. She's an amazing gift to workers' comp. I mean, everybody that speaks to her or knows that and has read any of her writings. But that's one that I guessed right on, and I think that's a critical part in establishing under LaBeouf or Dahl. Or, I'm sorry, LaBeouf or Ogilvy.
I fully agree that under Dahl and its progeny, that if there is not, you have to have evidence of amenability or lack of amenability to participate in rehab. But the question I still haven't really been able to figure out myself is how does one prove that? I mean, other than a VR expert saying, in my opinion, they're not amenable, what are the factors that are going to show that? I mean, is it the same thing that we're using describing their disability, the work restrictions, all that kind of stuff?
I think it's a combination of the medical evidence on work restrictions. I think it's the functional capacity evaluation and the ultimate VR.
So how is that? So I guess
I know what you're saying, but we don't have any.
But so in other words, to me, it's a magic buzzword that a VR expert has to say. Just like them saying, I conclude that they have a total loss of earning capacity because of all these work restrictions and the FCE and all of that. They're saying, I conclude that they're not amenable to voc rehab because of the work restrictions and the FCE and all that. I'm not trying to downplay it. I'm just not sure that. I know it's what we have to use because the courts have given it to us, but I really don't know if it's all that different than the have they suffered a total loss of earning capacity.
And I would submit it's not. It's not. It's
Well,
like we used to have proved that they can't compete in the open labor market. Remember, we'd have to define what the labor market was and all of those issues. I think it's all sort of the same package, that somebody has to reach a degree of disability before we'll have that conversation. I think it's just different language, but the same concept is are they total? Can they go out there and get work?
Well, tell me this: you're not saying LaBeouf is a total. You can apply LaBeouf to something less than total.
You can, but the courts have been. I mean,
well, I agree with that. Pragmatically, you're correct.
Right.
The court looks at the higher, but if you, why wouldn't you apply LaBeouf in a life pension?
Well, you could. LaBeouf wasn't a total
Exactly.
disability case. In fact, Judge Rose Bird, who wrote the decision, set that out. But in LaBeouf,
how many Court of Appeal and recon decisions have said that it only applies to total disability in error?
That is an error.
Yeah.
Because in that case, I think
every time I read that, I go, what?
A shop steward for the union testified that this guy's job or his ability to work was much more impactful than what the permanent disability rating was in that case. So it increased the rating, but it wasn't a total disability case. But yeah, I agree. I mean, but I think in these cases, whether it's 4662 or the Fitzpatrick case, or what the judge is looking for is somebody who really is going to have a tough time getting out there and finding work, right? I mean, that's why the work restrictions are so important. I think it's all kind of part and parcel to the same issue.
So let me ask you, defense attorneys, as a defense to a case where you see someone is going for total disability using a LaBeouf / open labor market / diminished future earning capacity / not amenable to rehab, are you going to tell your clients or suggest your clients, hey, let's provide this person with a rehab program, and perhaps even provide them with something more than what the voucher currently provides or what the law requires? In other words, say we're going to spend some actual money to put them in something that was more akin to the old voc rehab days and see if they can actually participate and benefit, right? Spend $5,000, $10,000, $15,000 as a potential defense to a total disability case. Is that something that ever comes up in the...
I can read it on Jake's face. Why don't you answer that question, Jake?
It's a really good question.
Yep. I actually think that there's some merit to the idea, but it would only make sense to do in a case where you had an employee who was actually really motivated to go back to work.
Yeah.
Because if they're not motivated to go back to work, you're just paying to show that they don't want to go back to work, which is one of my problems with FCEs. FCEs, I think, are meaningful where you have someone wants to show they're able to do something and they want to go back to work. If the goal of the FCE is to show they're totally disabled, it'll show they're totally disabled because they won't do anything. So
Yeah, let me-
I have some real questions about use of FCEs from that standpoint. But I think the rules that we operate on basically is the voc rehab evidence. If it doesn't show total disability, basically inability to benefit from vocational rehabilitation or inability to return to work, I think it's going to be a tough road to be able to do anything.
Yeah.
And then it always becomes a question of why is it? Are there language issues? Are there, earnings issues, intellectual issues, all those things that contribute to your ability to go out and find employment? Those are things that defendants have to emphasize in terms of looking at it. So I've had cases where the rehab counselor says, yeah, this person probably can't go back to, isn't going to be able to go out and compete. They can't benefit from rehab. They don't have enough education. They don't have enough intelligence. They don't have whatever it takes to be able to go. They're monolingual. That really limits their ability. If you removed all those impediments, they could benefit from rehab. And that's the defense I'll present in those cases.
Yeah, and so there is a concept, apportionment, rehab apportionment. So if there's reasons other than the industrial injury for their inability to compete or a total loss of or diminished earning capacity, then you can, argue that to say they're not total as a result of the industrial injury. So be aware of that.
Those are called the Montana factors for the Montana case. But I was just thinking when Jason was talking about how back in the day, and you guys will remember this 20 years ago, where the concept of vocational permanent stationary would come into play, where if they had not been through vocational rehabilitation, they weren't deemed vocationally permanent stationary, and it was hard to move forward on a permanent total case until you got to that point in the case. Well, we really don't have that anymore because they've gotten rid of vocational rehabilitation, and so when we're dealing with these VR issues, we really don't have a complete record. We don't have somebody engaged in a voc rehab plan, failing that plan,
Well, that's because VRTD never ended, did it?
Well,
that was the problem.
Well, there was that.
But the consequence of the prior process is the vocational rehabilitation issues got more worked up. We had more data to go off of, and now we're with this Dahl case, like, okay, they're not vocationally amenable. The only way you can really establish that is through voc rehab expert, but it's not because they went through the process and failed.
Let's talk about that. I think it's important who we select to do the functional capacity evaluation from the defense side, and also on the applicant side, as well as our VR experts. There are VR experts that just are not credible, and there are functional capacity evaluators that are not credible, and we all know that, and all it does is muddy up. I seldom throw a name out there, but I'll bet you everybody here uses her, is Rachel Feinberg as a functional capacity evaluator. She does a stellar job. She's a straight shooter, and that's the type of person that I want on my case, because I need to understand my potential liability, and I need an honest assessment. I don't just want to go off to a functional capacity evaluator or a VR expert that's going to give me what they think I want. So. Okay.
Should we talk about Lund?
We should.
All right, this is on page 12 of the materials. This was a case where the injured worker was found to be totally disabled due to combination of a low back injury, psychiatric impairment. There's kind of a lot going on in this case. One, you had a psychiatric injury that was arguably a compensable consequence of the physical injury, and it's a post-1113 case, so the general prohibition of psych impairment under 4660.1c applies. However, on the facts here, there was a finding that this person's injury was catastrophic, I think due in large part due to they said the intensity and seriousness of the medical treatment, which involved a 2-disc compression and fusion surgery, supported a finding of a catastrophic injury, and they cited the Wilson case. In addition, there was the use of addition, that is the use of kite. The doctor here opined that, quote, aggregation, which I guess is another word for addition, was the most accurate way to combine the various impairment ratings as opposed to using the combined values chart. And finally, there was vocational evidence that found that the worker had suffered a total loss of earning capacity and was not amenable to vocational rehabilitation. I think what's interesting about this case is that there was medical apportionment. That is, the doctors had apportioned somewhere between 10 and 20%, I think it was 10% each, of the impairment that they assigned and the resulting disability to non-industrial causes. But because of both the use of addition, which you take after the rating, after apportionment, that final number, you would add it to another number, and the fact that the vocational evaluator in this claim opined that the total loss of earning capacity was solely due to the work injury, that the board was comfortable in awarding 100%. Now, this is not always going to be the result. I have had cases where I've had vocational evaluators say that they are totally disabled and it is totally due to the effects of the work injury, whereas the doctors have given medical apportionment and the board has apportioned off of 100% award based on the opinion of the medical evaluators. And quite frankly, I don't know how to square those decisions. I don't know why in some decisions like here, the board says, basically, notwithstanding the medical apportionment, we're going to find an unapportioned 100% award. And in other cases, they say, no, there's medical apportionment, and they will discount the VR expert's opinion because they failed to take that into account. In any event, that's the Lund decision.
Just one comment on that. All the evidence.
And the next case, the Swanson case, is actually in many respects very, very similar. Where you have an applicant who has multiple body parts, low back, neck, gastrointestinal, esophageal, psych, bladder, all of which end up with an opinion that the applicant is permanent, totally disabled. There's a prior cervical neck fusion where the agreed medical examiner apportioned 15% for the neck fusion to non-industrial. The vocational counselor testified that all of the disability was directly caused by the industrial injury. What it's hard to tell is whether all of the disability after you took out the 15% cervical was going to add up to a permanent total. It might have, or whether the disability in the low back, esophagus, psych, and bladder alone was enough to cause permanent total disability. It might have, and even though you have a medical apportionment, it may simply not be enough. So I think when you get cases where you get 10% or 15% medical apportionment, you're more likely to get hit with the idea that the disability is directly caused, which I think is the wrong standard. I think we need to have more aggressive cross-examination of voc rehab counselors. Among other things, I'd be asking them if the applicant was less disabled, would you still be able to say that they were totally disabled? If the disability were less, would they be as disabled? That's what apportionment is. The disability would be less as a result of the industrial injury. So I think there needs to be a more aggressive tack. And frankly, I think we need some Court of Appeal decisions. This actually isn't a Court of Appeal decision. This is a writ denied by the 5th Appellate District. And they will, on occasion, write a memorandum and say, here's why we're denying the petition for writ of review. But it's not a decision. It's not citable authority. We really don't have citable authority on this issue of what you deal with vocational testimony that says all the disability is a direct result, when we know actually medically it's not a direct result because we have other medical evidence that's substantial evidence.
Well, tell me this, Jake. Don't you believe that that there can be a different level of disability depending on the measurement, medically versus vocationally?
Absolutely.
Okay.
Yeah, because a lot of times
you agree that you can have different levels of apportionment, whether it's medically or vocationally?
I think the vocational apportionment is a different concept.
Sure.
Than medical apportionment. And I think the vocational counselors are stuck with the medical evidence. I don't think the vocational counselor gets to decide the disability as a result of the industrial injury, because all they look at is somebody who's working before, now they're not working. So they're using a but-for test. That's not our test anymore. So I think you have to challenge them on how they're making that calculation. And the fact that almost everybody has some pre-existing impairments that limit their ability to perform work activities. So you have to go over that with the vocational counselor also. Were they able to do every job in the labor market? Of course they weren't. Were they able to be a professional football player, nuclear scientist, an astronaut? No, they didn't have the capabilities for that. So they had vocational limitations. So now you're talking about what's directly caused by it, the limitations in terms of what they're doing now.
Yeah, my point was, though, that they can be different. And
they can be.
Yeah.
Yeah, so the question then is, can the vocational apportionment, if there's even such a concept, trump the medical apportionment? And I had this issue as a judge, and I ruled that it didn't. That if there's medical apportionment, well, I think I agreed with you, Jake. I said there really is no such thing as direct causation any longer in workers' comp, and so that if there was medical apportionment, the voc rehab expert relying on the medical evidence can't come up with an alternative opinion regarding apportionment.
Okay, when you say there's no longer direct causation, I think there is, respectfully. But I think that it's not the but-for test.
Not the way they're using it here. They're
Okay,
basically
okay.
trumping the medical apportionment, saying that all of the disability relates to the industrial injury. So basically, the vocational rehabilitation expert is reassessing apportionment.
Well, are they saying that, or are they actually saying that given this level of physical limitations restrictions, the vocational expert says that he's totally disabled?
But in order to get to total disability caused by the industrial injury, you have to say that the vocational evidence can trump the medical evidence. That's the only way you can get there.
Okay, but why can't you say that? Because there are alternate methods of establishing, and I don't know why I'm arguing for 100% on the
I don't know
applicant's
why I'm
case.
arguing what I'm doing, and I would definitely not argue this in one of my cases. I'm just saying that if you really look at the rationale here, it is vulnerable. It's subject to question.
Okay, but aren't they different theories? That's my point.
I don't think they are.
They're not independent.
I think the vocational evidence flows from the medical evidence, so you can't say that they're independent criteria. I don't-
Absolutely, but it's a different measurement.
Let me give you an analogy.
Okay,
I
sure,
used this
sure.
once with a doctor, and it was successful, at least in this case.
I sound like a defense attorney.
I know,
I-
we're switching here.
I asked the
What
doctor.
he said, I agree.
I asked the doctor to imagine that my client is this vessel, and we're pouring liquid into the vessel. That liquid represents
You've
disability.
seen this from me, haven't you?
And
This is my analogy, ladies.
And at some point, as I'm pouring it in, it's going to reach the top and it's going to spill over. And if I continue to pour into that vessel, I'm pouring more in, but it's not. It just spills out. And so the idea is someone can actually be more than 100% disabled, but in other words, doctor, if this is the worker and we pour in just the industrial component of the disability, does that on its own reach 100%? And I've had doctors say yes, and I think that may be what you're saying about the vocational, saying, look, even if I parse out however they do it, this 10, 15%, and take just what's left, that still is enough to get them up to 100% on its own. But I also appreciate it's kind of a tortured argument.
Yeah. Yes.
Yeah, see, I think actually if they make that argument, it makes more sense than to say the direct causation and I get to ignore the medical apportionment. If they say, if you really take that out, the remaining amount of impairment, the remaining amount of disability, they're not going to be able to do anything with that. I think that makes sense. And I think you can look at, we have a whole bunch of cases that say you may apportion part of the psychiatric, but if you take all the rest of it, the orthopedic, the neck, the back, that's enough to make it 100% by itself. You don't care about the apportionment. That all makes sense to me. You can do that.
Right. Like if you added them all up after apportionment, if you get to 100, you get to 100. That's sort of the.
Get to 100.
Yeah, it's 100. I get that.
But my point is, can you have less than 100% rateable disability, medical disability, and still have a vocational expert come in and say, you're effectively 100% disabled vocationally?
Well, isn't that the Lund case? I mean,
That's what I'm saying.
Yeah, so.
Yeah, that's LaBeouf. I mean, well, LaBeouf never said the applicant was 100%.
Right.
LaBeouf just said you need to consider voc rehab testimony in consideration. So in some respects it's misquoted, but the effect of it is you consider the vocational evidence in order to consider the impact of the medical restrictions on the ability to return to work. So yeah, I think you can have somebody who's less than permanent total, but the combination of disabilities is such that they really can't function.
Okay, the next case is presumptions. Dudley's going to explain to us how the defendant can defend a presumptive case.
So yeah, so I
can't?
much of my caseload are public safety cases, and so I spend a lot of time in presumptions. On page 13 of Rich's materials is the Blair versus City of Torrance Police Department case. And so as most of you know, there's a difference between local safety and state safety. The local safety counts of presumption is found in Labor Code section 3212.1. And basically what that says is that after the last day of active service, you can extend the presumption 3 months for every year of service, up to 120 months, I believe it is. So up to approximately 10 years, you can extend the presumption. So in this case, it's quite interesting to see that the last date of work here is 2001, and the cancer diagnosis is 2018. So if you're looking at just extending the presumption, in this particular case, there's no way you can get there, okay? So what I guess it's a board panel. What the board did here, and the trier of fact, is they looked at the language in the code section that talks about the presumption being triggered by not only the manifestation of the cancer, but also the development of the cancer, okay? So for years and years and years of doing these presumptive cases, you're always talking, at doctors' depositions, you're asking, well, what's the first manifestation? What were the first symptoms? What were the first, ultrasound findings? Whatever it is, you're trying to find when that cancer showed itself. Well, if you focus on the development language, the analysis is very different. You're looking at when the genes first began to mutate as a result of the carcinogenic exposure. The analysis is very different. And here, that's what the board did, is they looked at when they looked at the latency period for the cancer, and they looked at when this cancer was in fact starting to develop. And that brought the employee all the way back to their active service. And they said, well, if that's when the development began, then the presumption clearly applies. I would just note for the audience that this is a very broad interpretation of the applicability of the cancer presumption. If this becomes the law, I would say that it will be virtually impossible not to invoke the presumption in any cancer case for the employee groups that qualify for them. So this is very broad. I have actually cited this case a few times since reading it. And the defense attorneys that I'm dealing with don't seem all that impressed or fearful of this particular decision. I'm still arguing it, and I'm going to trial on the development question in one of my cases in the very near future. So that is the City of Torrance case. Very interesting case for people that do this type of case.
Isn't it true, Dudley, that oftentimes defendants try to avoid liability in a cancer claim, even a presumptive claim, by arguing latency? In other words, they say, hey, it couldn't have been this agency because this person only worked there for 6, 7, 8 years. This cancer has a latency of 10 to 15 years, whatever it may be, which means it was actually the agency the person worked at 20 years ago, and they bring in that other employer.
So that's the Faust versus City of San Diego case, and the only time I've ever seen a presumptive cancer case beat or defeated is by a latency period argument. Exactly that. That's the only way that I'm aware of that you can actually defeat one of these claims. And it's ironic that where that's a potential defense, in this case it's being utilized to in fact extend the applicability of the presumption. That's the irony of this case, exactly.
Well, that's my point, is
Right,
that,
right.
yeah, it's been a defense argument. Now, though, it's something that us applicant attorneys need to be looking at and going, okay. And the same is true for heart claims. I literally had a deposition with a doctor yesterday in a presumptive heart claim where the condition arose more than 5 years after my client stopped working for the agency. And the manifestation, the echocardiogram that showed LVH, was 7 or 8 years after my client retired, which is outside of the maximum 5-year period that's typically allowed if they work the requisite years for a heart presumption. But the question I was focused on was not the manifestation date, but when was it developing, right? If someone has chronic hypertension for 20 years, I think it's medically arguable that their underlying heart condition, heart trouble, whatever it may be in your case, probably was developing long before it actually became manifest. So if you're doing presumptive claims, take a look at that, think about that issue.
One of the things that I'm puzzled by this is the difference between latency and development. Ordinarily, we talk about latency not in terms of when did the condition first exist. It's when was the exposure that led to the condition.
Right.
We talk about in asbestos cases, you're exposed to asbestos 20 years ago, you developed cancer a year ago. We go back 20 years and say, well, it was the exposure 20 years ago that caused you to develop cancer now. In this, the applicant doesn't appear to me to have had bladder cancer in 2001 or before, while he was reported during the 5 years. It's supposedly the exposure, but the development, not just development manifestation, but the actual development is 20 years later. So I'm thinking that the board is misunderstanding the difference between latency and the development of the actual disease process. There's no evidence the applicant had bladder cancer 20 years ago.
I think that's
Bladder cancer is a relatively recent onset.
I think that's the explanation.
But that's a really valid point, Jake, because in my case that's going to trial, the doctor said that the genes began to mutate 7 or 8 years ago, which puts me in the extended period, but that the latency actually is 20 to 30 years, okay? And so the defense attorney believes that the doctor's opinion as to the development has to be supported by a study journal article, something that the doctor's best clinical judgment isn't sufficient. So the defendant is trying it based on a substantial evidence argument, but I'm arguing that the QME's opinion as to when those genes started to mutate, when it actually started to progress, is sufficient. So, but it's exactly that issue, and I'm drawing the distinction between the difference between latency and development, that they are in fact not the same thing. It's interesting, anyways. If you do these cases, it's interesting, I guess.
Well, we had a conversation before. The only cases that I've ever been able to be successful in where the presumption applied have been latency. That's the only defense that I think, or an absolute, there's no evidence of exposure.
But most doctors will give you a 50% margin of error when providing a latency period. In 32 years, I've yet to lose a presumptive cancer case.
Well, what do you mean a 50%? What do you mean by that?
Anytime you're arguing latency periods, you're looking at different studies that show you basically, for any cancer, whether it's prostate cancer, leukemia, you will find different articles setting forth different latency periods.
I agree with that.
So there's a very significant margin of error when it comes to dealing with latency periods. There's just a great deal of speculation when you're talking about latency periods. So that's a tough issue. Granted, you can beat a cancer case based on that. I still think it's a tough way to beat it. Yeah.
That's why the LNH rule might be the right one. Last exposure period.
Yeah.
Everything else is all speculation.
Well, yeah, the way the presumption's written, though, it's a very, very strong presumption. Yeah. It just is.
Okay, we're pushing in the last hour.
All right.
So let's see if we can't. The next section that we're going to discuss are psychiatric injuries. And when we go through this, what I wanted to do was just have a checklist for everybody again, so we're all starting on the same page, pursuant to really 3208.3, but also 4660.1. And the first question that you want to ask yourself about psychiatric injuries is whether or not they arose out of either actual employment events or are pled as a compensable consequence to the physical injury. Where they are arising out of actual employment events, the standard is going to be outlined in 3208.3. Number one, 6 months of aggregate employment, unless it's the result of a sudden or extraordinary event or act, and we have a whole area of case law on that. Number two, the psychiatric injury cannot be substantially caused by lawful, non-discriminatory, good faith personnel action. We have a whole area of law on that. Result in a diagnosis, it has to result in a diagnosis of mental disorder which caused disability or the need for medical treatment. There's not a lot of litigation on that. It's probably a given. And then the injury arose out of actual events of the employment, which are predominant as all causes when combined. So we say predominant by preponderance of the evidence. Or where the actual events of employment involve the applicant being a victim of a violent act or direct exposure to a significant violent act. And we have case law on that now as well. Where it's pled as a compensable consequence, there we're going to have to go through the 3208.3 test that I just went through. So is the psychiatric injury predominant to all causes industrial? Number two, if the psychiatric injury is a compensable consequence of the compensable physical injury and predominant to all causes, then is the compensable consequence psychiatric injury the result of a catastrophic physical injury? And we're getting more and more case law on that, or from the applicant being a victim of a violent act. And we originally thought that was a criminal event, but we have case law that suggests otherwise. Now, an injury will be catastrophic, and this is what I've said from the beginning, and we're seeing the courts really adopt some of these tests, but it's going to be determined catastrophic. I said from the beginning, mechanism of injury, we don't have those cases yet, nature and extent of disability, and nature and extent of treatment. And the courts seem to look at those in determining whether or not the injury was catastrophic. The next case that we're going to discuss is this Munoz versus Department of Corrections. This is a good faith personnel case, and that's Jake's.
Yep. No, this is actually in some respects a very helpful case, because one of the things that frequently comes up is how do you identify something that's a good faith personnel action, particularly personnel action, versus something that's simply part of the work environment that might cause an injury. And this case talks about that difference. In this case, the applicant received an email which went around to a bunch of people in the office saying that we're going to have a meeting at X time in the office. Everybody should be there. The applicant, for some reason, was convinced that the purpose of that meeting was to fire her. And it's unclear where that perception came from, but she reacted emotionally to receipt of the email, filed the claim, and ultimately the QME indicated that her psychiatric disability arose out of that particular email and her perception that she was going to be fired. Defendant raised the argument that this was a personnel action, that if she was going to be fired, that's a personnel action. And the court said, we're looking at the distinction between a work environment issue and a personnel action. In order for it to be a personnel action, it has to at least have had the capability or the potential for affecting her from a personnel standpoint, and this email didn't have that. It wasn't about her. It wasn't about her personnel issues. It was about an in-office issue in terms of work activity, not based on her own individual work, and therefore it does not meet the criteria for being a personnel action. When I read this, what I looked at it and said, I'm wondering why this isn't one of those cases that fits into the criteria of what we used to call an honest misperception, which was compensable prior to the predominant causation threshold that we have. But honest misperceptions are no longer a basis upon which a psychiatric injury. She did get an email, but it was not about anything she was talking about. It's a completely separate thing. So she put in her own mind, I'm going to get fired at this meeting, when in fact the meeting had nothing to do with that. I think there's an argument to be said that that's actually not an honest misperception, or it fits into that category where it's not actually a workplace event. It's the applicant's imposing her perception of something that's not actually occurring. But apparently that wasn't one of the arguments that they raised. They just talked about the personnel action.
Okay, in the box, I cite a number of quick cases here. The first is the Milla versus United Guard security case, and that just stands for the proposition that it's the defendant who has the affirmative, has the burden of proof on the 6-month aggregate employment issue. The next case is the Strum case. This case addresses violent act, and it was a crushing amputation of the finger constituted a violent act. The next case is the McKee case. This is going from top to bottom. And this was holding that psychiatric injury was not barred by the 6-month employment rule, where a fall from a loading dock while walking to the cafeteria is not within the ordinary risk of her job as a nurse case manager, and therefore found to be sudden and extraordinary as an exception to that. The next is Garcia. This is another Garcia case, but this one's properly spelled. Holding that in reaching the predominant cause threshold for psychiatric injuries, the court may aggregate the percentage resulting from causation resulting from both compensable consequence of physical injury and that which is the direct cause of the injurious event itself. And so that's a new case on that. I had not seen that before, Jake. Had you? Were they?
I haven't seen it, but I've had the issue come up, and I've always assumed, based on the way the statute reads, that you can aggregate all industrial causes as long as it's the same employer. Doesn't matter about the carrier, but the same employer. You can aggregate industrial causes because it just talks about predominant causation. It doesn't say predominant causation for an injury.
Yeah.
So I've always assumed that you can aggregate multiple causes to meet the predominant causation threshold as long as they're all related to the same employer.
That makes sense. Okay, the next case is mine, and this is a kind of a strange case. What happened was the applicant went to the restroom. He looks down under the stall, and there's another co-employee, he didn't know at the time, who has the iPhone, presumably. No, it's got to be a Droid. And he's taking an image or a picture of the applicant. At the time, the applicant didn't know who it was, but he was able to identify the coworker as a coworker and who he was because of his shoes and socks, I guess. So that says something, obviously using a Droid. Anyway, and so the issue was whether or not that was actual event of employment for the purpose of establishing a psychiatric injury. And the WCAB held that actual events of employment occur when, one, the event happens in the employment relationship, and two, the event must be of employment such that it must result from the employee's working relationship with his or her employer. In order to qualify, and they go on to that, but they discuss the fact that the neutral risk for non-personal reasons, but they discuss the fact that, you know, using the restroom on the employer's residence or premises is in fact, you know, under the personal comfort doctrine, and therefore within the course and scope of employment. Under these facts, they went on to write, under these facts, applicant suffered psychiatric injury predominantly caused by actual events of his employment when applicant's privacy was invaded by a coworker who took photographs of him while using the restroom facilities. Application of the personal comfort doctrine brings the use of the restroom within the employment relationship, and because the event of videotaping the applicant while using the restroom was committed for unknown motives or no motives at all, i.e. non-personal neutral, the doctrine requires that the resulting injury is compensable. So they found that compensable. I just, you know, if I had this, I'd probably deny it, and then I'd argue nature and extent, because I don't know what the disability would be associated with that.
I'm wondering if the worker here has a separate cause of action against that employee directly for.
Well, we know. Let me just say this: there is a statute in California that prohibits taking restroom photography. So this is an odd case, but certainly explains. Yeah, I'm excited to take that case on.
Yeah.
But actual events of employment explains that. The next one, oh, geez, poor Jason. This is. Tell us about this next case.
I feel like this was Art Johnson's case down in San Jose, but I could be wrong. Let's see here.
I don't think it was Art. I think it was.
What's that?
I don't think it was Art on this case.
Yeah.
I'm not sure.
I'm making stuff up. So apologies to whoever's case this is, and I'm misrepresenting. I apologize. In any event, this is kind of a horrific case. So this person had a number of accepted injuries or claims that were filed, became accepted, and started treating with the Dr. John Massey. And the doctor sexually abused this person. I mean, just inexcusable, horrific conduct that no one should have to endure. This poor person did. And as a result, they claimed a psychiatric injury as a result of the sexual abuse, and the defendant denied it. Now, let me just pause here. Rich, client calls you, says, hey, we've got this claim. A doctor that's been treating in the course of the industrial injury, for the industrial injury, treatment paid, provided for by the carrier, doctor sexually abuses this an injured worker now claims a psychiatric injury as a result of that. What are you going to advise your client to do?
Halkias. That's what I'm going to say. I'm going to say that generally injuries are arising out of the treatment, especially where it's a new or different condition, are probably going to be compensable.
Right.
Is that your point?
Yeah, and in fact, that's what they did here. They cited Aikido and said this arose out of treatment, the facts are so compelling.
Yes. I would tell my client that we probably need to accept and treat.
Yeah, I'm sure there's.
Would you agree with that, Jake, or not?
You know, I was part of a panel that worked with the appellate attorneys on this. We did a appellate argument. We had a roundtable where we talked about this case. There were like 7 or 8 other defense attorneys, and there were like 3 different attorneys on the defense side. They're all appealing against each other, in addition to against the applicant. None of the defense attorneys thought that the argument about causation, the psychiatric injury, was going to go anywhere. In fact, I'd said if somebody had given me, if I'd had this case to go up on appeal, I would never have taken that case up to the Court of Appeal, because I wanted them to focus on the other issues, not on that. And that's too easy a one for them to pick off and spit out, which they did. But part of the arguments were also one of the defendants saying, well, it wasn't our treating doctor. We can't get caught for that. they still had part of the psychiatric care. They're going to get stuck with it. But there are a lot of sort of sub-issues. This is the longest Court of Appeal decision I think I've ever seen.
Right. Now,
73 pages.
I'm looking at the decision here, and it took me about 2 minutes of scrolling just to get through the headnotes to the start of the decision. It was Art Johnson, and
Okay,
I'll right. But part of the issue here is that Mr. Johnson, as he sometimes does, was arguing that his client was totally disabled. And in fact, I believe he did obtain an award of 100% permanent total disability at the WCAB. However, that was annulled by the Court of Appeals because I think of the issue you talked about where there's multiple defendants here, right? So it's just, you got to
Actually, it was a reversal on Fitzpatrick. The board decision came out before Fitzpatrick. The Court of Appeal decision is after. The Court of Appeal actually asked for additional briefing on Fitzpatrick, and Art's response was Fitzpatrick was wrongly decided. He didn't argue his case. He just said Fitzpatrick was wrongly decided. You need to not follow it. And the court basically said we're following Fitzpatrick. So that's why they reversed. It was a 46-62, according to the fact decision at the trial level on the board.
So, yeah, I think the point is there's a whole lot here. It's in the materials, I think, on the limited issue of the psych and the nature of the injury and all that, which, again, on those facts, I mean, it's horrific. But, yeah, there's a lot going on in this case. But if a treating doctor sexually abuses an injured worker, that's going to be an industrial injury.
Well,
it was even worse. He was giving her excess medication to try and control her so that he could continue the relationship. It's a very, very sordid story for the whole thing.
It's terrible.
Yeah.
Gee. Okay.
He lost his license, by the way. Not that anybody should be surprised.
But thank you for that little bit of justice. That is.
Yeah.
Jesus.
Okay.
The next case, Mike?
Yeah, the next case is yours,
Dudley.
Dudley.
Chavira versus Southland Gunite, and it's on page 17 of the materials. So this case dealt with the catastrophic exception under Labor Code Section 4661C2B and the en banc decision in Wilson versus State of California CAL FIRE that told the parties what they needed to establish in order to establish catastrophic. This case is significant because it emphasized that catastrophic is not measured by an injury's impact on an employee's earning capacity, but rather the focus should be on the treatment and impact which the injury has on activities of daily living. So we're not just looking at how it's affected their earning capacity, we're looking at a larger picture when assessing catastrophic. So that's the significance of this case.
Well, you know what I did when I reviewed this case? I didn't really understand why it couldn't be both. Why they felt that it had to be activities of daily living. They seemed to link that to whole person impairment and focus on that rather than, other aspects of the case. And so I was kind of confused by that. It seems to me that catastrophic ought to consider a number of factors, and we ought to leave it to the trier of fact to determine whether or not it's a catastrophic injury.
Right, I think that's what this decision said, is that they looked at the diagnoses, it was a very severe injury.
But what's the distinction?
They were encouraging taking a broader view,
Yeah.
not just looking at one factor.
But why is disability not one, is my question.
I don't disagree. Yeah, no, I think disability should be one of them, the residual from an incident. So I totally agree. I think what they're saying is, though, look at the activities of daily living, look at, the diagnoses involved, the totality of the circumstances.
And that's exactly. Do you see a distinction there? That's what the court said, Jake, but do you see a distinction between disability and, I know they're different animals, but why not include both?
I think they're just trying to throw as much as they can to justify the result. In this case, to me, the medical treatment sounds like it's a catastrophic injury. Multiple hospitalizations, sepsis, congestive heart failure. I mean, this has catastrophic consequences from a relatively, didn't appear to be a significant injury at the time, but clearly was in terms of the effect it had on the injured worker. And they're just kind of trying to include all the things that they can into it from that standpoint. But for me, just like Wilson, I thought Wilson was catastrophic in the beginning. The guy was hospitalized and almost died from inhaled smoke and flames. He had burning in his lungs. I could never understand why they just say that's clearly catastrophic from the get-go. I think this one probably meets the same criteria from that standpoint.
Okay, the next case I like. In fact, I just recently used it on a case that I'm working. That's the Perez case dealing with serious and willful misconduct. That's yours, Jake.
Yeah, this is, you're right. This is from a defendant standpoint. This is an interesting case because it emphasizes a couple of things that are important in any serious and willful misconduct. In this case, the applicant was the operations manager for this particular company, and apparently they would go around and update facilities that involved selling used cars. And what they would do is they had a whole bunch of employees, but he was the top of the food chain basically for the operations part of it. The people who went out and actually did the work itself. The other people, there were 4 other people that were identified as being principals in the business. He was one of the principals. The other 4 having to do primarily with the financial and business end and personnel management, but not the day-to-day operations. This guy was out of the facility where they're going to do some work to rehab it. He goes up on the roof and, for reasons that nobody is really quite certain, falls off the roof. He's not engaged in fall protection, which he should have, and dies. And they settled the underlying case, and then the defendants file a serious and willful misconduct claim alleging that there were a violation of OSHA rules and that the conduct he engaged in, the conduct was serious and willful misconduct on the part of the employer by setting him up on the roof without fall protection. What the employer presented was evidence saying nobody put him up on that roof except himself. Nobody told him to go up there. There's nobody on site supervising him. He's the one who's supervising everybody.
Exactly.
He had another employee at the time. And one of the requirements in order to impose liability on an employer is there has to be a managing or supervising employee who tells the injured worker, the person who gets injured, go do this with knowledge of the violation and the consequences of it. And in this case, they were able to show there's nobody that told the injured worker to go up there and do it. There's nobody overseeing him, no oversight. He made the decision on his own. They actually showed that they had an aggressive safety program. They met all the requirements for having an active safety program. And as the court noted, the board noted, the fact that there may have been an OSHA violation in and of itself doesn't mean it's serious and willful misconduct. You have to show that the managing person from the employer knew about it and told the injured worker to go and commit the violation. In this case, the managing employee was the person who did it. And so we're not going to attribute that conduct to the employer because the employee did something that on their own violated the OSHA regulation. They didn't show that the employer had any knowledge or any complicity in the environment, ended up with a take nothing on it. So it's a pretty good instructive case from the standpoint of some of the requirements for S&W.
So, Jake, I'm going to change the facts a little bit on you. So, same situation, but now instead of the supervisor, a regular employee goes up onto the roof at the direction of his manager, falls through a hole in the roof because he doesn't have proper safety restraints and netting. And the evidence shows that the safety manager knew that there was a hole in the roof, knew that they needed safety requirements, did not tell the employee to use that, and sent the employee up on the roof. And that's what caused the employee to die. Do you think that constitutes serious and willful?
Well, first of all, that would never happen. But if it did, absolutely. There's no question.
Yeah.
I'd be trying to settle that case as fast as I can get it out of the door.
I ask because I have that case, so.
Okay, let me.
You're just making that up. It's not possible.
I have
unfortunately
kind of a variance on that whole thing. Right now, I've got a 20-year supervisor who the employer testifies under oath that he was not directing him and he wouldn't have stopped him from doing what he did. He got a cat and rolled this tractor down the hill. He's got pretty serious injuries. Turns out that the cat was only there to hold up the yarder as a weight, a tether weight. It was not supposed to be used, but this guy who'd been their supervisor for 20 years and was running the job, and nobody would have walked up and said, you can't do that, did what he did. So it's a little of a variation on that, and there's a Cal OSHA violation. I sent this case when it came down, when I saw it this past year, I sent it over to opposition, and now we're probably going to settle that case because I think it's a lot closer call.
Yeah.
So.
Well, yeah, I think if you have a supervisor or a manager who is the employee, that's a tough S&W. I mean, as far as the willful/knowledge part of the S&W, that's a tough case.
Well, what about a reverse S&W, right? Could it be both? I mean, there's, right? Is it?
Oh, have you ever seen one of those win, though?
Right.
It just.
You know what? When I took the specialist exam to be a workers' comp specialist, there was like 3 or 4 questions on a reverse S&W, and I was like, when is this ever?
Yeah.
Who writes that? Somebody who's being clever, huh?
Yeah.
Right.
Okay, now we're almost at the end here. We're at page 18, and we have 2 cases. Oh, Jake, you're up again. The supplemental job displacement benefits.
Hold on a second. These are the supplemental job displacement benefit case. The first one is simply, I think, a common sense issue. If there's a dispute over whether the employee is entitled to a supplemental job displacement benefit, even though the case has been settled, and this is a case where the case is settled, the employee now says, I'm entitled to the benefit. The employer says, no, you're not. So they say, okay, I want to do discovery. And the defendant tried to prevent them from conducting any discovery, saying, this case is settled. There's no basis for discovery. And the court said that, in effect, is saying the injured worker doesn't have a right to seek a benefit that the law allows them to have. And, of course, they can conduct discovery. And frankly, I'm not even sure what kind of discovery you would need to do. It's such a strict liability benefit. I don't think an injured worker would have much trouble showing entitlement to it. I think a lot of people don't understand it. They think you have to show medical eligibility to get the job displacement voucher. It really has nothing to do with medical eligibility. It has to do with whether the employer actually provided them with either employment after they were released to return to work, or they made a job offer. Otherwise, they get the benefit, even if they're released to return to a usual and customary job with minimal disability. So it's a strict liability section. But yes, they can conduct discovery if it's necessary afterwards. I think that's pretty straightforward. The next issue is actually not a supplemental job displacement benefit. It actually sort of fits in the next category, and it has to do with establishing whether an employer made a valid offer of alternative or modified duty. And apparently in this case, the employer sent a text to the employee saying, we're offering you work, but the text doesn't really give enough details to the employee that it showed what their job duties were going to be and whether the job was within their employee restrictions. It just said, we're offering you modified duty. And the board said that's not enough to show that you made a legitimate offer of modified duty to terminate temporary disability benefits. You have to make an offer where the employee can understand what their job is and whether they're physically able to do the job. And then if they decline to come back to work, then you can terminate temporary total disability benefits. So that's a different kind of situation. And of course, we also have the one where the job is abandoned or they refuse work and at a later date become temporarily disabled. And the question of whether they get temporary disability then, they may not, unless it's a different kind of condition where, for instance, they have surgery. You can't offer modified duty if they're having surgery.
The next case is.
By the way, I was going to say, I use the supplemental job displacement benefit to help settle disputed cases.
Oh,
if I have an injury, AOE, COE, I'll throw it in. It's $5,000 to the injured worker. And I've done that on a lot of cases where I had alcohol intoxication defenses, AOE, COE defenses, independent contractor defenses. I just throw it in and give them the voucher just to help fund the liability and make it easier to settle the case.
And what do you do? Do you stipulate that in the body of the CNR?
Yeah, I usually have a separate agreement with the applicant attorney will provide the voucher. I don't usually put it in the CNR. We usually there's also sort of a side agreement that the applicant won't apply for the voucher, will just apply for the benefit. But I also tell the client if they apply for the voucher, you have to give it to them. I don't think you can actually have a side agreement where they don't get the voucher.
Yeah.
So if they apply for it,
I think that'd be borderline potential fraud if you said we're going to provide a benefit, but they're not going to use it and just use it to get to 5,000.
We have a case on that.
That's what I'm saying.
Yeah.
So.
So I
What do you do with Beltran?
I don't say that you can't use it. I just
Ignore
say,
it.
you know, we have an agreement that they won't, but if they do it, I don't think there's anything you can do about it.
Yeah.
Okay, but what about the flip side of this? I don't want to give it up. I want to settle with the Thomas, and I want to include Beltran to wrap up. I know it's only a panel decision, but the judges are honoring that.
Some are.
Some-
We've had a really tough time with some judges on it.
I did. I think it's a correctly decided decision.
Yeah.
I mean, it basically follows Thomas. I followed it. I know some judges have an issue with that.
Yeah, I think Beltran's perfectly good law. It's the
Right.
exact same language was in the book rehab statute. Exact same language. Doesn't make any sense that Thomas isn't binding on it.
Okay, the next case is a temporary disability case.
Yeah.
And that's yours, Jason.
Yeah, so Gonzalez, this is on page 18 of the materials. This is regarding one of the exceptions to the typical 2-year cap on temporary disability, specifically the high velocity eye injury. So the facts are the worker was hit in the eye and the face by a rock that was thrown from an unknown source as he was walking to his vehicle. Hit him hard enough to knock him unconscious, I can't say that word. There's a few words I can't say, consciousness. He was unconscious and suffered fractures to the orbital wall of his eye and other injuries. There was an allegation that the high velocity eye injury exception applied. The defendant apparently disagreed. They went to trial. The judge found that it applied, and that was upheld by the board. Basically what they said is, even though we don't know exactly how fast the rock was going or who threw it or where it came from, that the nature of this worker's injuries were sufficient to infer that whatever hit him in the face was moving at enough velocity to cause severe damage and make him lose consciousness. They go, it's reasonable to infer that that was at a high velocity. And of course, the statute doesn't define high velocity, right? It just says that it has to be a high velocity object. Now, I'll tell you, I had a case a couple years ago that I went to trial on, also on this issue, but where the high velocity object was my client, in that he fell some 30 or 40 feet from a rafter, landed on his face onto a concrete floor, suffered quite, frankly, catastrophic injuries, although amazingly he's back to work.
Okay, I had a case where a sandblaster was hit with some sand. The injury, the applicant was on TD forever, and the injury was not serious, although he extended, and the argument was this is an exception,
Right.
which I...
Well, in my case, what was interesting is my client also suffered orbital fractures. Lots of fractures, but specifically orbital wall, cheek, face, serious injuries requiring multiple surgeries. And the QME in the case, God bless him, said, no, that's not a high velocity eye injury. So I said, okay, doctor, what was it that caused these injuries? Was it my client's face hitting the ground at a high rate of speed? Yes, it was. Oh, okay. But we went to trial, and the judge found that it was a high velocity eye injury, because even though I think the statute contemplated an external object moving at a high velocity, that's not what the statute actually says. And so the injury was caused by something moving at a high velocity. And I actually had somebody ready to testify with the physics equation to show how fast my client would have been moving at a fall of that height by the time he hit the floor.
Did that go up?
No.
Oh, I haven't seen that case.
No,
That's interesting.
there's no panel decision because defendant, I think, wisely didn't recon it. So,
Okay.
yeah.
Okay, the last case that we're going to discuss is assigned to me. And it's a case involving temporary disability where the applicant was held temporarily disabled, and then somehow, after the injury, the applicant or the employer found out that the applicant's Social Security number was not valid. And on further investigation, he found out that the applicant was not here legally. And the issue is they had medically appropriate modified or alternate work, but the applicant could no longer participate in that because the employer ironically found out that he was illegal.
Ironically?
Well,
Come on.
I'm being sarcastic.
Okay.
But the employer found that out and terminated or argued, the defendant argued that he was no longer entitled to temporary disability. You know, this is if Bill Herreras was here, this is a pet peeve of Bill Herreras.
you want me to pound the table as if I'm Bill?
Yeah, go ahead. Shake
Well,
the
because
computer.
look, he railed against the Solace decision when it came out.
Yeah.
Really.
He spoke at my conference the year that came out, and really.
You're giving the employer the benefit of this person's labor, and if we all think that employer didn't know that person's documentation status, I mean, give me a break. But now they're going to, oh, gee golly whiz, we figured out they're undocumented. Oh, we can't hire them. You don't get it both ways. It
does give the employer incentive to start checking everybody on temporary disability to see what their status is. I think this is a bad precedent.
And it flies in the face of 1171.5
but
that says that immigration status is irrelevant to the determination of entitlement to workers' compensation benefits.
But this is a preemption, federal preemption case.
Federal
law preempts state. That's what the ruling is here.
I
and
understand.
You can't get around. That's constitutional.
I can dislike it.
Well, listen. I understand that you might find it not fair. But that is the law. And so we either choose to change at the federal level what the law is, or we honor the preemption, federal preemption.
No, I understand. I needed to channel my inner Bill. It's righteous indignation.
When Bill discussed, he said the same thing. He was upset about it. And the only thing I could add was to what he was saying is that's our rule of law.
That's right.
So. Okay, what we're going to do next is we're going to treat ourselves to a longer break than otherwise would be the case. We're going to take a 20-minute break. We'll come back at about 10 to 1, and we're going to take some questions. If you have some questions that you want to text to my phone, I'll go ahead and take a look at them, and I'll read it off, and we'll do that for 10 or 15 minutes just to make sure that we're compliant with the CEB requirements. So that'll be about 10 to 1, and then we'll take another break, and we'll come back at 1:15 for what everybody wants. It's not us wagging our jaw, it's the giveaways. So, and I'm going to have retired Judge Dudley Phoenix do all the drawing because nobody would question his propensity for truth and veracity. Okay? Okay, so let's we'll come back about 10 till. Okay, I have a number of questions that have been texted to me. I'm just going to throw these out to the panel. I'll just read them word for word. Is providing an FCE sometimes something that should, they keep coming in, that should go through utilization review, even if the PQME or AME says that an FCE would be a good idea or helpful in determining work limitations, but stop short of saying it's necessary.
I could jump in on that. So I would respond to that, and you guys may disagree, but that there's a very significant difference between medical legal recommendations and medical treatment recommendations. So if the QME or AME is saying that an FCE needs to be completed as part of their evaluation, I would say that UR doesn't apply and that it's part of the medical legal process and it should be authorized. That'd be my point.
I guess the question is, do we want that functional capacity? On my side, I'm not really afraid of it because as long as I have a good evaluator, what do I care? Right. You know?
First of all, I think anything requested by an AME or QME should never go through UR.
Yep. Great.
It's not a UR, it's not a treatment issue. It's a medical legal issue.
Right.
So if they think the test is necessary, then it should be authorized. And sometimes, for instance, during an EMG, if you're looking at whether somebody's a DRE2 or a DRE3, EMG can be crucial to make that determination. So that may, even though you may say it's not necessary from a treatment standpoint, it may be necessary from a medical legal standpoint. Same true with an MRI or an X-ray. There may not be a medical reason to do those studies, but you may need it in order to be able to evaluate the person from a medical legal standpoint. So I usually, when I get an AME or QME writing and saying I need to have these studies, I usually write back immediately and say you're authorized to get them.
Yep.
My cover letter said you could get them, just get them, and let's move on. So medical legal things should not go through UR. They're subject to fee schedule, but not utilization review.
Okay, the next question, this is from Jeremy Smith, good guy. He says, first of all, thanks to everyone. And then he says, Ray, UR denials. One of the main frustrations is not so much the denial and the rationale, but there's no alternative proposal from the UR doctor. It would be helpful in every claim if instead of just saying no, they offered an alternative. Does that have to be legislatively? Well, it does. or can a defense request? Well, defense can request it. Surely it would be to their benefit.
Yes, and if the UR doctor recommends something in the alternative, approve that. I've seen cases where the doctor says, well, this isn't medically necessary because they haven't had this first, and then so the doctor requests this that they identify, and that gets denied by UR. And then and then you're just yelling at the wall, so.
The next one's by, I think, I'll just throw this out there. I only say good things about people. I never say bad. But there's a chiropractor, QME, that we all use, and that's, who is that?
Well,
Jacob Moses?
Oh, yeah.
Yeah,
Moses,
he's a good guy. Anyway, he asked the following question. Does the PQME AME have to use the word synergy to apply kite? I don't think you have to use, well, you don't have to use that word, but you have to explain why it applies.
This has been a pet peeve of mine, that kite has become shorthand for using addition, and I think that there's a distinction that needs to be drawn. Kite, in my opinion, stands for the proposition that evidence of synergy is one basis with which a doctor can say that using addition is more accurate than the CVC. However, so if you're using synergy, as in bilateral impairments, knee, left hip, right hip, et cetera, I think that synergy is important. However, I also believe that addition can be used in the place of the combined values chart, absent evidence of synergy, if the medical evaluator says that that is the most accurate way to combine the disabilities and represents the most accurate representation of the disabilities, and explains why. And the basis for that belief is the Devereaux case, which was our office, where we took at the trial, addition between a cognitive and a cardiac disability were upheld. Neither doctor said that there was synergy, but they both said that addition was most accurate. That was found at trial, upheld on recon, upheld by the Court of Appeals, or writ denied, and the Court of Appeals awarded attorney's fees, saying there was no reasonable basis for the defendant to seek the writ. So I think there is, if not binding, at least good case law that you can use addition without saying synergy.
Yeah, and I think they
I think synergy can be a trap. Some doctors simply think that if they say synergy, it means kite applies. You still have to have the rationale. So synergy is one way of getting there, but I agree with Jason, it's not the only way to get there. I think it's overused, but a lot of doctors think it's a magic word and allows them to say, add it, when they really don't have any idea of why they're saying to do it. They're trying to find a way to increase the disability. One of the things prohibited under Guzman is to simply trot through the AMA guides and look for a way to find an increased disability, or use Alvarez-Guzman solely for the purpose of increasing disability. The whole idea is supposed to be accuracy, describing the impairment better, not just finding a way to describe it as higher.
And there are two cases that came down a number of years ago, about 4 or 5 years ago. That's the Pride and Joy case, and I can get you the site if somebody out there wants it, and the Barrett case. And they both discuss the principle of synergy, and they're not really discussing it in terms of aggregation versus combined value. It's just whether or not the aggregate of a number of different rating strings increases the overall disability. So I think we all agree that you don't have to use the word synergy, and it turns on substantial evidence, your analysis.
Yes, right. Yes.
Okay, the next one is from David Barlow. These people probably didn't know I was going to give their names.
They're like, wait a minute.
Yeah, I feel like a talk show host.
You're going to get text saying I retract my question.
Now, this is good. This is a good question. It says, why is it that the AA and DA agreed to AMEs or use of PQMEs to resolve all issues, but when report is low PD, AA goes back to PTP to secure MMI report and then wants to settle on a higher PD based on the PTP? What's the purpose of an agreed medical examination in that case? Even after sending the report to the PTP, report to PQME for comment, he does change his opinion, and the WCAB have said blah, blah, blah. I think the reason that the app attorney, if the PD's too low, goes back to the QME or AME is because if it's too high, or the PTP, if it's too high, we go back to the PTP as well, because both are admissible. The only admissible medical legal opinions are the treating physician and the and the medical legal evaluator.
I can't speak for Jason, but I have to say, I don't. That's not a practice that I engage in. If I agree to an AME, I may take the AME's deposition to make sure that doctor's got it all straight, but I'm not going to try to then get out of the AME by going to the treater. That's just not something I do in my practice.
Good for you.
And same for me, for a couple reasons. One, for the reasons Dudley said. Two, up in Northern California where I practice in Sacramento, most of my PTPs typically aren't going to write a report. They're bothered. I mean, it's just, and so to me, what the question describes is something that happens in Southern California much more than in Northern California. And I can't speak to agreeing to AMEs in doing this, although I have had cases with SoCal attorneys where we have an AME and we get the report, and the first thing I get is an angry letter from the SoCal defense attorney saying, I object to the AME report and reserve my right to cross-examine and blah, blah, blah. And I'm like, thanks? I mean, what the, okay.
You understand the purpose of that is to keep you from filing a DOR right away and to give them some time to talk to the client about the file. But probably not going to do anything. It's probably a canned letter they send out.
Yeah.
What Jake's saying is absolute. You realize that our clients, just like your clients, have to, think about what has just happened and where the case is going.
Yeah.
So, okay, here's the next question, and this is Jake's question. If an employee quits job, is the employer still liable for supplemental job displacement benefits for a lack of job offer?
Absolutely.
Yeah, I think so.
It's strict liability.
The liability for the supplemental job displacement benefit is an absolute liability unless the employee returns to work within I think it's 30 days after temporary disability ends, or the employer makes an offer of alternative modified duty on the correct form. So, I have cases where clients argue with me, well, we made an offer of modified duty to the employee. I look at the offer. It's temporary modified duty. It doesn't indicate it's going to last 12 months. I said, this doesn't comply, and it's not on the form.
Right.
It's a strict liability statute that you have to comply with the statute in order to satisfy the obligation to provide the voucher. So, look at what the statute says. This is really an easy answer question. If you haven't made the offer, you're out of luck.
And what's the en banc decision? Is it Dennis? Was that the decision?
I think it is, yeah.
About the prisoner, right? Where they said, we can't offer modified work because they can't come back into prison or whatever the facts were.
Yeah, they've been released from prison. We can't give them work.
I think that was out of the Sacramento board, actually.
Yeah.
Yeah, but they couldn't offer modified work because they were a prisoner,
And they were
they
no
still
longer
owed the voucher, like Jake was saying.
Yeah.
It's strict liability. I mean, if that person's not back to work, you're issuing the voucher.
And if you weren't timely in the offer, too.
Right.
Okay, the next question, I'm just going to kind of modify this a little bit. If somebody isn't here legally, what, if any, benefits, if they're injured, what, if any, benefits are they entitled to? So somebody here is working illegally, they're not in the country legally, and they sustain an injury. What, if any, benefits are they entitled to? And the whole list is here. And I think we covered a lot of this, but do you want to take that, Jake, or you want me to run after that?
I think literally they get all the benefits you're entitled to in workers' compensation.
Except?
Obviously they couldn't get voc rehab. Well, they couldn't get job placement previously under the old voc rehab statutes, but they can still get voc rehab. So they literally get every benefit other than those things that the employer cannot offer as a matter of law, which would be return to modified duty. If the employer has the ability to return to modified duty. Other than that, they get temporary disability, medical care, permanent disability, supplemental job displacement benefit, dependency benefits. They get all those.
Yeah. Other than TD per that case that we talked about.
Well, that's the exception.
Yeah.
Okay, I'm not sure about this. I'll just read it word for word. What is everyone's stance on employers officially offering PERM mod if MMI with modification duty is 0?
I don't understand.
In other words, you're released. I'm interpreting this to mean the person has been released to their regular job. They have no limitations or no modifications of their job. They may have disability, but their job is compatible with it. They're released to their regular job without restrictions. And if they go back to work, they're fine. If they don't go back to work, even though they're released to their regular job, the employer either doesn't take them back or they've gone to work for somebody else. If they don't get the job offer, they get the supplemental job displacement benefit.
What was the last part of it?
Again, strict
Yeah,
liability.
with no PD. I don't even know how that would happen.
Yeah.
Okay, here's probably the most important question. And this, should I give the name of this person? No, I won't. It says, am I finally going to win something? What's everybody?
Survey
The answer is
says.
yes.
Yeah.
I've seen the prizes and they're pretty nice.
Okay, I'm not going to go through the rest of the questions because guess what, ladies and gentlemen? We have satisfied our obligation for the minimum time for continuing education. So let's take another 10-minute break. We're going to put up the prizes, and then we're going to have the judge go ahead and pull the...
All right.
Okay, thanks so much. We'll be back. Give us 10 minutes and we'll have everything up, so quarter after.
More important than anything.
Okay, we're back for the raffle. And we're going to start out, we're going to go from the best gift to the worst gift. Okay? We've got our honorary raffle referee here.
Well, I used to be, but we'll have to just deal with it.
And what's the best gift here, gentlemen? Go ahead.
It's obviously the Workers' Compensation Index, written by our near and dear friend, Rich Montalvo.
So the first one we're giving away, and this is why I'm doing this, because everybody's only in there once, and somebody is going to say, oh, crap. Okay? So we're going to give this away to begin with.
All right, are we
Okay,
ready?
a drum roll. Here we go.
Okay, these were thoroughly mixed up. The winner is John Carty. Wow, congratulations, John.
And you notice they're large because last year somebody told me that they couldn't tell who actually was drawn. And again, that's John Carty, C-A-R-T-Y. The reason I'm spelling that is my staff is at the office taking down everybody that draws. Okay, the next one is a pretty good gift. It's a gift card. Whoops, from Amazon. $100 gift card.
Nice. Are you ready?
Yeah.
All right.
I'd
Next
take
winner
that.
is Melissa Gillahan.
Melissa Gillahan.
Wow, congratulations.
All right, $100.
Have fun.
$100. And by the way, this is a combination of money raised by the sponsors. Okay, we have two of these. If you're like me, you have two vices. One is good wine and the other one's coffee. So, and some would argue this isn't the best coffee, but it's pretty good. The first gift certificate for Starbucks, and you get one of these as well. Look at that.
Wow.
This is
Oh my
a
gosh,
classic.
That is fantastic.
Current
actually.
issues with coffee.
Do you sell those?
No.
I like
no,
that.
what happened was a number of years ago, I had a bunch of these printed for my clients. It's kind of a, and it says current issues with coffee, and it says Montalvo law on it.
Like it
And-
when you were exhibiting, it was your swag that you would write.
No. It had to do with one of the conferences we have here, and everybody that got specialty coffees got one of these. And so this is a classic. This is a vintage cup now. So we're going to give that away along with a $50 gift certificate to Starbucks. Okay.
Here we go, next one. It is Tracy McKenzie.
All right.
All right, way to go.
Serving a very important role here.
So again, that's L. Tracy McKenzie.
All right, so you want to do the
Okay.
second one here?
Well, hang on.
gonna take it from
Let's
the,
see what the second one is. Oh my gosh! Oh my gosh! It's $100. $100. See how that works? No,
Wow,
what
that's
happened
like
was
magic.
I had my ladies prepare these, and I said, "Well, what about the $100?" And so one of the ladies in my office said, "Well, why can't we just tape the dollar amount on over the one?" So they did that. I thought it was done yesterday late when I said, "Well, hold it. We have more than one." So this is the $100.
Go to the bottom for this one.
Okay, we're going deep.
Going deep.
Are you going to draw any there, Jason?
How can I compete with the judge?
Well,
Sean McAleer.
oh wow.
Yeah.
Yeah.
You know Pat McAleer back in
Yeah.
the day.
Is that
Yeah.
any relation?
I don't know.
I don't know.
Okay.
What's that?
Oh, is that you? Are you related to Pat McAleer? No. Oh, he's a defense attorney from way back when. A really nice guy.
All right.
Yeah, he's up in Reading, I think. Yeah.
Okay.
Okay.
Next,
Jason, you're up next.
This is a gift that is near and dear to my heart, and that's a $250 gift certificate for Cabela's Bass Pro. How's that?
That's a nice gift.
Yeah. If you like to fish, hunt, or
Elizabeth Mariana Patalo. Elizabeth Mariana Patalo. If I mispronounce that, I'm sorry, Elizabeth.
Wow, very nice.
Okay, we're going to hold off on this one and this one.
Oh man, this right here.
Yeah. Okay, this is an exciting gift. This is a copy of the work comp or of the labor code.
Stephen Scott.
Oh boy. Right now
Stephen
he's
Scott.
saying, oh crap.
Not the gift I was hoping for.
You know, I could use a second one because I got the one at the office. I need one at home. You
Got
know.
mine with me today.
That's right.
Okay, let's go ahead. We've already given away this, which is the work comp index. Somebody excited to get that. Let's go ahead and grab a bottle of wine.
All right. Wow. Look.
These are nice bottles of wine. Which one are we giving away? Philip?
You think we should taste them first?
I think we should open them and taste them.
All right. This is Phillips Togny. It's a beautiful bottle.
And the winner is Patricia Hastings.
Wow. Congratulations.
Congratulations, Patricia.
Now these wines were all selected because they're good enough to, they may be young,
You put it.
but they're nice enough to drink now, but they're certainly something that you could put up.
This next one looks really, really fancy. It's a Wallace Family Estate. It's a Cabernet Sauvignon. It is a very, very attractive bottle.
LaQuoya Pittman.
Wow, nice job.
LaQuoya Pittman. All right.
How is that? Let's give away one more bottle and then we'll move on to something else.
Okay. This is just, wow, very stunning bottle. It's Matthew Wallace, and that's, you know,
Huh?
it's a Cabernet Sauvignon.
Oh,
You'll like that.
This is great. Matthew Popish.
Oh, Matthew,
No,
congratulations.
hold it. I think there's been a problem here.
I was hoping that would happen. This is great. Congratulations, Matthew.
Matthew, it's a good-looking bottle right there.
Okay, let's go ahead. You know what? Let's give away a lesser gift. Right here's some earbuds, Apple earbuds. Let's give those away.
I love my earbuds.
Yeah.
I love those.
And I've got the pros
you're,
too.
You're not wrong. You wear them. I see you with them all the
I
time.
wear them all the time.
All right, Douglas Berman. Hey,
Oh,
Doug.
nice job, Doug.
All right, Mr. Berman, congrats.
Okay, we need to mix that bowl up.
Okay, here you.
All right.
No. I
need
can't
another
The
tell
problem is
you.
you mix them, they start falling out.
Okay,
Okay, that's pretty mixed, right?
we'll give away now the Bud Pro
Second
model.
bud. Second bud.
Oh, this is the Pro.
Oh, the pro.
Yeah.
Rhonda Perez.
Nice job, Rhonda.
Rhonda.
Those are nice. I don't know if I have the pros. I might have just the.
You got just the normal one.
Do I have? I need to upgrade. Wow. All right.
Okay, you know what we're going to give away next? Let's step up our game here. We're going to give away an Apple Watch. How's that?
Wow.
An Apple Watch.
Molly Finnegan.
Molly, congratulations. That is nice.
Nice.
An Apple Watch.
Yeah, my
Man.
gosh.
We're gonna go back to the judge here to.
Okay. Yeah, you want to mix them up a little bit
hold
there?
on.
Okay, on this one, we're going to give away a HomePod Mini.
Wow.
This is
These are the nicest gifts I've ever seen.
Yeah, thanks for saying that.
Really nice.
Yeah.
Okay, I'm reaching here. Are you ready? Okay. The winner is Tala Toe.
I think that might be Paula.
Okay.
I think that's a typo.
A little typo,
If
but
there is
you
a
know.
Tala Toe out there, you won, but I think it's Paula Toe.
Paula, yep.
Yeah.
You know what? I'm just reading the.
Good
the
for
names
you,
here.
Paula.
Great job. Yeah, these are.
Okay, let's give away another. Should we give away another Apple Watch? No. Let's give away. We have 2 iPads. Let me tell you, because of the supply chain problem, we only have one of the iPads here, and that's a Mini. Is that right? Yeah. We're going to give away the iPad Mini.
Wow, very nice. All right. This is Guadalupe Gonzalez.
All right.
Nice job, Guadalupe. That's excellent. There's that. Okay.
And then we're going to give away the full iPad that's in transit, I'm told. It may have ended up at my office today. I think it was set for delivery today. But we're going to mail, I'll be taking all these back, and then the ladies in my office that are recording this, as well as Sean, we'll mail all this stuff out. Okay, the next is a standard size iPad.
All right, here we go. It is Chris Ron Vongs Sarath. I'm not sure I'm pronouncing your name correctly, but congratulations. Excellent gift. Wow.
You don't mess around, Mr. Montalvo.
No kidding.
You know, a comment is justified. I have to pay people to listen to me. Okay. The next one is another watch.
Wow,
An
okay.
Apple Watch.
We're going to go bottom dwelling again here.
Oh, boy.
All right. This is Christopher Daner. Chris Daner with Jones Clifford,
Oh, geez.
attorney in San Francisco, friend of
Okay.
mine.
Okay, but-
excellent attorney.
Applicant attorneys are not eligible.
Great job, Chris. Way to go. Representing the applicant's attorneys.
Okay, so that's the Apple Watch that he won.
Nice. Yep, very good.
Okay, this is a significant gift.
That's
Wow.
Huh?
Holy
this is
smokes,
for
I'll wait.
all the, I don't want to be sexist here, but men
Don't be
who are,
sexist.
who are sharply dressed and then women.
I no joke. This suit I'm wearing came from there. Actually, all my suits came from there.
Yeah,
I'm
yeah,
just-
but what happened? They closed the store.
they closed
in
the
Arden.
Sacramento store.
Yeah.
I know.
Oh, I didn't know that.
Yeah.
We should tell them what we're talking about.
Yeah, well, I'm not going to guess what this is. You know, we're going to do the Johnny Carson deal here. Okay, this is a $500 gift certificate
bad.
from Nordstrom's.
That's
That's nice. Very nice.
$500 from Nordy's.
All right, we're going in then, right?
Okay, we're going deep.
All right, going deep. This goes to Trang Ortega. You
Oh,
saying that
great.
right?
Yeah.
Very nice. Great job. That's a good one. Wow.
I think she's an adjuster.
Yeah.
Yeah.
Yeah. Congratulations, Trang.
Yeah,
Good
we'll
job.
expect a
Well
lot of referrals to competitive defense firms. Don't send me anything.
Okay. Well, another
listen,
bottle of wine?
Yeah, let's do a bottle of wine.
Okay,
Which
Jason,
one
you're
do
up
we
on
have
this
there?
one. This is a Genera, another really attractive bottle. It's another Cabernet Sauvignon 2019, and there you have it.
Don't you love the way Dudley announces these bottles?
Well, I like wine, so this
It's my dear friend Susan Wynn. She's all of our friends. Let's be real.
Way to go,
But
Susan.
Susan, congratulations.
That's awesome.
I can name some people that might want to share that with you.
Okay, let's give away that next bottle of wine.
All right, wow. Okay, this is wow, what a nice bottle. Moon Sai Cabernet Sauvignon 2016.
Oh my gosh.
Really, this looks delicious.
Hey, wait a minute. Someone's stocking the pond here. Kirsten von Sareth is. This is. Yep.
I think we've already announced that name.
We did. He won.
Are you kidding?
Oh. They.
Okay, I'm sorry. You
Oh,
only get one
all right.
option. That was
Sorry, that's
and feel free to file a lawsuit.
Alexander Hansen.
Wow.
All right,
Very
Alex.
nice job, Alexander. This looks delicious. Perfect. All right.
Stock the pond. Okay, we're going to give away. This is an iPhone Pro, 13 Pro.
Ooh, man.
Yeah, I have one. I think everybody has it. These are great.
They
They are
mine.
great.
Yeah, they're excellent.
Who is the lucky winner here?
Wow.
Lambert Crone.
Wow.
Are you kidding me?
Is that you, Bert? I think we should disqualify present company. I think the fix is in. Wow, Bert, that is a heck of a
Holy
gift,
cow.
man. That is.
And listen.
Wow.
I'm not
No,
pulling anything.
This is all
How
random.
is that?
Congratulations.
Yeah.
If this corresponds with the AIG directives, of course.
Yeah, let's not get you fired over this thing. Very
Okay,
cool.
a drum roll. We have one more gift.
All right,
this
the
is,
MacBook. Wow.
yep.
Let me put that down there to the
Mac Air. Mac Air.
man. Oh man.
Oh, this is the new one. This is
Yeah.
with the M1 chip and everything.
Yeah.
Wow.
Boy, good for you.
I'm a nerd.
You see, that's what I'm using.
I'm
This
a-
is exactly
Yeah.
what in my office we're using.
That's what I'm using
Yeah,
too.
it's great.
Yeah.
Who is it?
Marietta Harrison.
Oh, geez, Marietta.
Way to go.
If
That's
you're not
a-
an Apple user, you should be, and now you will be.
That is
You-
that is
you-
nice.
We switched to Apple years ago. I don't. I sound like a plug for Apple, but I like Apple.
You know what I'd say is security. Windows is not secure, but Apple is.
Yeah.
Okay, that concludes the 27th annual Current Issues Workers' Compensation Conference. I want to thank everybody for their assistance in presenting the materials, and also, I'll be frank with you, my staff did a lot of work on this. I just kind of show up and wag my jaw. I'd also tell you that Bert Cohen has just been handcuffed and taken out. Okay, I mean, Crone. Anyway, we're adjourned. Thanks so much.
All right, thank you.
On behalf of the law offices of Richard L. Montalvo, we hope that you have enjoyed our presentation and thank you for viewing our conference. Current Issues Workers' Compensation Conference is held annually on the third Friday of March each year. We look forward to seeing you later this year at our October Rating Conference and next year again at the 2023 Current Issues Workers' Compensation Conference.